Senator Huffman, you're recognized for a motion to suspend the regular order of business on Senate Bill 1124.
Thank you, Mr. President. Members, at this time, I move to suspend the regular order of business, take up and consider Senate Bill 1124. Members, when the legislature passed the Michael Morton Act in 2013 to revise criminal discovery, it used the state, in quotes, as a term in a manner that blurs the roles of the prosecutor and the investigator or agencies in providing discovery to the defense. As a result of this ambiguity, the Texas Court of Criminal Appeals in June 2024 held in State v. Heath that a trial court may suppress relevant and incriminating evidence of a defendant's guilt for failing to disclose it upon request, even when a prosecutor had no knowledge that the evidence existed at the time of the initial request. This ruling applies even when the prosecutor acted in good faith and the defendant suffered no prejudice from the non-disclosure. Unfortunately, defense lawyers are now taking advantage of this technicality by not specifically requesting evidence that they know a law enforcement agency has failed to turn over to the prosecutor. Then at trial, the defense can invoke Heath to have it excluded. This gamemanship undermines the integrity of the trial process and core principles of justice. Senate Bill 1124 seeks to rectify the unintended consequences of the Heath decision, which permits the suppression of an inculpatory evidence without requiring a showing of bad faith by the state or any harm to the defense. And I want to emphasize this bill does not apply to exculpatory, impeaching, or mitigating evidence benefiting a defendant, nor does it prevent a court from suppressing evidence in cases of bad faith by the state or incurable prejudice to the defense. The bill clarifies the definition of the state, quote unquote, for discovery purposes, distinguishing the responsibilities of prosecutors from those of law enforcement agencies. The bill also establishes new procedures for requesting discovery, empowers courts to limit overly broad discovery requests, and codifies pre-Heath common law standards governing the suppression of evidence. Many of the elected prosecutors throughout the state have worked carefully on this legislation. Myself and my office has worked with them. Our goal has always been to seek justice, make certain that the Michael Morton Act is being preserved and implemented as intended. This change will ensure that our criminal justice system is weighted equally for both the victims and the accused, but making very sure that all the defendants' rights are protected as established by the Michael Morton Act. With that, I move suspension of the regular order of business.
Senator Menendez, for what purpose?
Questions of the author, Mr. President.
Senator Huffman, do you yield?
Yes, I do.
Senator Huffman, thank you very much. As you know, I'm not an attorney, and I don't have that background that you have or the judicial background experience that you have. But unfortunately, I have an attorney on my staff, and there's a question of concern, and I think you may have addressed it in your layout, but I just want to make sure we get it out and clarify it. One of the concerns is that the court's discretion to limit discovery by limiting evidence or documents necessary in order to prove their case. It's a concern that it could cause difficulty to prove innocence. But I think in your bill layout, you said it excludes the information that could benefit the defendant.
Exactly. Anything that's exculpatory, that means, shows that they're innocent. Mitigating, which could mitigate their guilt or mitigate the punishment, or anything that would, that the prejudice could not be cured by the court and some other remedy, then the bill would not apply to that type of evidence or information.
I've heard from several district attorneys that this is meant, and I think you said it yourself, to level the playing field.
Yes.
And one of my concerns is, could it result in your opinion, do you think this could result in increased false convictions? Because that's a concern for me.
Absolutely not, and I would not sponsor this legislation or write this legislation if I thought there was any chance that we were, leaning towards false convictions. That is not the intent whatsoever. We simply want to, as I said, level the playing field and have these situations where inculpatory, that is, incriminating evidence, is suppressed, even though it's clear that the defense knew about it or the judge has other remedies. For example, the judge could grant a continuance to give the defense time to respond to the fact that now the prosecutor has presented more evidence. So there are many tools in the hands of a judge to ensure that the defendant's rights are protected, but also make sure that the defendant's rights, the victim's rights are protected. For example, one of the prosecutors who testified, I think it was Mr. Dick, I don't remember which county, I think he's from Williamson County, which is ironically the county that the Michael Morton case arose from. And that DA went to jail many years ago for his actions involving in that. But he testified to a case where during the course of the presentation of law enforcement on the stand, they testified about another body cam that he had on that the prosecutor just simply didn't know about it. It was still in the records. It had been preserved, and it was an indecency with child. And within those records were many pictures of child pornography, including with the victim. And the judge suppressed that evidence, even though it had been wholly unknown to anyone that that there was, I take that back, it wasn't a body cam, it was they discovered they had taken possession of the defendant's phone. There was another one with body cam evidence. This one dealt with the defendant's phone, and in the phone they found these photos, but that was suppressed. Now, clearly that was very important evidence because those indecency and those child cases are very difficult to prove anyway, and they're probably about a 50-50 loss on those, because many times the evidence just goes to the testimony of the child, which sometimes jurors have a hard time, convicting someone of a very serious offense. But certainly that evidence, hard evidence, unrefutable evidence, was suppressed, and that could never have been, that's not justice. Now, should a continuance have been granted for the defendants, perhaps even a mistrial granted and start all over? There are different remedies that you can take to preserve the defendant's rights, but this Heath decision has led to outcomes that all of us would agree are not justice. And so, yes, it's a balancing act. I understand your concerns, but I have confidence that the system can work through these issues and achieve appropriate and just results.
Well, I think you said it best a second ago when we talk about making sure that we don't convict anyone falsely, but by the same token, we need to protect the victim's rights to get a fair trial so that the person, the perpetrator, can deal with the repercussions of their crime. And so I had been opposed, but I think after conversations with my DA and other DAs and yourself,
Yes.
I think I'm going to be able to support your legislation just because I want to make sure that victims of crime know that they're not alone and that they'll get a fair trial, and that we can't allow for a judge to suppress irrefutable evidence like that, those images.
Yes.
That makes absolutely no sense. And even like you said, they could get a continuance, they could get a new trial, but you can't suppress the evidence. So I thank you for answering my questions.
Thank you, Senator.
Thank you, Mr. President.
Thank you, Senator. Secretary will call the roll on suspension.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
25 ayes, 6 nays. Rules are suspended. Chair lays out on second reading Senate Bill 1124. Secretary, read the caption.
Senate Bill 1124 relating to discovery in a criminal case.
Do you recognize passage to engrossment?
The passage to engrossment of Senate Bill 1124.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell.
25 ayes, 6 nays. The bill passed to engrossment. You recognize to suspend the constitutional 3-day rule.
So moved, Mr. President.
Secretary will call the roll when ready.
Alvarado, Betancourt, Birdwell.
25 ayes, 6 nays. The rule is suspended. Chair lays out on third reading and final passage Senate Bill 1124. Secretary, read the caption.
Senate Bill 1124 relating to discovery in a criminal case.
You recognize on final.
Move final passage of Senate Bill 1124.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell.
25 ayes, 6 nays. The bill is finally passed. Thank you.
Thank you.